And let's now talk a little bit about self-managed associations. There's a special place in heaven for self-managed associations, truly. You have all the responsibilities, you're not getting paid. If you're small, it works, right? Because you only have a few checks you write every month, you only have a few checks that you need to deposit. It's work. But self-managed communities, they have the same fiduciary responsibilities, even though they don't have a management company that's helping them. Corporate behavior and governance for a self-managed community is the same standard as it would be for a larger community, a master plan community. You have to follow the law. We're going to talk about some laws that you need to know about. Now, a lot of the things that I'm talking about here for self-managed, these also apply if you have a management company, right? But I'm directly calling them out because with some management company associations, your management company just handles things for you. And you may not even know that they're occurring, but in a self-managed association, if you don't know about it, you don't know about it, and you don't know you're violating the law. So I think it's important to talk about what are some things. Okay, so we already talked about the governing documents. You have the same governing documents, of course. Same statutes. There's Arizona revised statutes. If you're a planned community, the Planned Communities Act applies to you. If you're a condo, the Condominium Act applies to your association. Also, the Nonprofit Corporation Act is going to apply to your associations. We talked a little bit about fiduciary duty previously when we were talking about board members' roles and responsibilities. Just to outline the different duties, and this is typically what boards get sued for, so I think it's important that we just spend a minute on it. So oftentimes we see breach of contract, boards breached the terms of the declaration or the other documents, and then we see a breach of fiduciary duty, which is going to be a tort claim, and that would be you fell below the duty of care. So you have a duty of care to run the association in a professional and business-like manner. You have a duty to make informed decisions, duty to hire licensed contractors, get advice from experts when you got yourself in a pickle. Duty of loyalty, you can't take actions that are going to benefit you. So for example, my son's only 10, but let's say he starts a lawn mowing business, right? And I want to hire Jack's Lawn Mowing to, be the landscaper for our entire association. That is a very bad idea, okay? So you shouldn't be hiring relatives, vendors that you may have a special relationship with, no kickbacks, obviously. So you want to be very careful that your loyalty is always to the corporation. And then you have a duty of confidentiality. This is a tough one. People always forget this. I even forget it too. Sometimes when I come home from our board meeting and, I hear a juicy scoop, and I think, well, maybe I'll tell my husband that, and I'm like, oh no, I better not. That's not something that should be repeated. So here's the confidentiality rule. If you talk about something in the open session, you can talk about that with anyone. Open session of the board meeting, okay? If you're talking about something in the executive session, you should only be talking about that with other board members, your attorney, your management company, maybe your insurance agent if it pertains to that, but you shouldn't be going and blabbing information that you hear in the executive session to other owners. Bottom line. And it's hard because sometimes you want to go tell your spouse, oh, you're never going to believe what I heard in the executive session, So-and-so is losing their house, there's a foreclosure, and they filed bankruptcy, and then your spouse goes to walking club and mentions it to her group, right? And then now the whole group is yik-yakking about it. If it's public record and they could have found it out themselves, let them find it out themselves. You should not be the person that's telling that to people. Okay, the different laws, we talked a little bit about governing documents already. The operations manual, love the idea of using a binder with all of your association's documents in it. Bring that to the meeting. Another thing that you should be thinking about is that all meetings of the association, the board, and regularly scheduled committee meetings must follow the Arizona open meeting law. And what does that law say? The open meeting law says that anytime a quorum of the board is present, so if you have a 5-member board, the quorum's going to be 3, Anytime a quorum of the board is present discussing association business, it's an open meeting, okay? So quorum of the board talking about business, even if you rode here tonight, right? 3 of you came and you have a 5-member board, just be careful that you're not talking about association business during the break or on your way home, because technically you'd be violating the open meeting law. So be careful. I have a lot of boards that say, well, we have meetings, but we don't make decisions. They're more like work studies. Can't we do that? No. The legislature passed a law 4 or 5 years ago that says work studies need to be open meetings, even if you're not making decisions, okay? So if you are questioning, should this be an open meeting or can we close the meeting? Remember, there's only a few times you can close your meetings. And the most common times that you can go into executive session are to discuss advice from your attorney, or if I'm actually there giving you advice, or I gave advice on the phone and you're relaying it, or I have an email or a letter that I've written and you're talking about it. 1 is advice from your attorney. 2, delinquencies and violations, right? And 3, if you're upset about a vendor, you know, an employee or an independent contractor that's working with your association. Those are the most common reasons that you should be going into executive session. Annual meeting. You have to have an annual meeting of your members once a year. That is the law. And we're going to talk in a few minutes about what are some tips to have a successful annual meeting. I have some associations that say to me, we cannot get a quorum at our annual meeting. What do we do? Well, I typically say try again, try a second time, and if you don't get a quorum at your first and second attempt, then give up. And the board that is in place, you know, at that time continues on as the board, right? And when we talk about the annual meeting cheat sheet next, I'll give you some tips. We call it succession planning. So you want to have a successor in mind so that you can get off the board. And I'll give you some tips on how you can get the quorum and try to find some replacements so that you can, you know, move on from your service on the board. Some other things that you should be doing is providing a board packet and an agenda for all your regular board meetings. We'll talk about that in a few minutes when we talk about the 1-hour board meeting. But if you're self-managed, you still should do a board packet with important information regarding your association. If you have a management company, they're probably doing it for you. Minutes, you have to take minutes if you're self-managed. The secretary is responsible for taking those minutes unless you hire a minute taker to come in. I'm certain that most self-managed associations don't have the budget, though, for a minute taker, so ultimately the secretary is responsible for that. We already talked about closed or executive session meetings. So the way the law is written is it's not user-friendly. So I tried to give you the easy ways that you can go into executive session, but the 5 specific things that you can go into executive session for, so outside of a regular open board meeting, the board can go into a meeting where it's just the board to discuss these subjects. 1, legal advice from your attorney, like I said. 2, is there any litigation pending? We got to talk about any pending or contemplated litigation. 3, do we have any personal health or financial matters about an individual association member or an individual employee or of a contractor of the association? We never see that. Okay, we don't really ever get personal health or financial information about an owner. I mean, that's just not something we see very often. Matters relating to the employee job performance, we do see that. You know, you're not happy with your landscaper, or there's a performance issue with your handyman or whatever. And then there's a 5th area that our legislature added about 5 years ago that says that if an owner wants to have, so you can discuss an owner's appeal of any violation or fine against that owner. So let's say that we have a owner who painted their house purple without approval of the architectural committee. And we can discuss that with the owner during the executive session unless the owner says, no, I want that in the open session. Okay, and I truly, since this law is passed, I have never had an owner exercise that. So we don't see that very often. So again, executive session, typical things that we see. We talk about advice from your attorney, if there's any litigation that's pending or we're thinking about actually filing litigation. Delinquencies and violations are the most common things that we go into executive session for. Emergency meetings. This is kind of a hard thing to define. Under the law, if you cannot wait 48 hours to notice a meeting, you can have what we call an emergency meeting. So what would be an example of an emergency meeting? Some other times that I've seen emergency meetings called is, let's say that you have a tree that falls on your clubhouse. You have a huge hole in the middle of your clubhouse. Or possibly, it's the hottest week of the summer and your pool pump goes out. We want to have an emergency meeting to vote to buy a new pool pump. So really, remember, emergency meetings shouldn't be used as a matter of course. These are special events where you can't wait 48 hours to notice the meeting properly under the law. Of course, we have to give 48 hours notice of any regular board meeting or any executive session, even if the owners can't be there. And so if you can't wait 48 hours to make a decision, then you can put it under the emergency meetings category. Remember, if you have an emergency meeting, that you are required under the law to take minutes, and then at the next regular board meeting, you need to read into the record at the regular board meeting the emergency meeting minutes, so that there's a record that there was an emergency meeting, why it occurred, and what was decided. The next thing you should have on your radar as a self-managed association is insurance. You have to have adequate insurance for your association. How much is adequate? Look in your CC&Rs. It'll tell you. If you aren't sure, talk to your insurance agent, talk to your attorney. For a lot of these associations where we've had situations where there's been embezzlement, a very good type of insurance to have is a fidelity bond, right? A fidelity bond protects you in the event that one of your directors or somebody who has access to your money steals your money, and you can make a claim under the fidelity bond and be made whole. So you want to make sure that that's set at an adequate level. You also want to have property insurance for your association, general liability insurance, directors and officers insurance. We have a whole cheat sheet on insurance if that subject is something that you need more information on. Compensation. This is a big one for self-managed associations. You can't be compensated to serve on your board. That's just the law. If the documents allow you to be compensated to be the treasurer, then you can do that. But most don't. Most definitely do not do that, so be careful if you're currently doing that. Talk to me, because I can give you some advice on how to handle that going forward so that you're not in violation of the law. Fraud prevention. Ensure that methods are in place to guard against embezzlement. Look at your bank statements. Look at reserve account checks. Must require 2 signatures of your board members. Checks are issued only with the board of directors' approval. No checks made payable to cash. No checks pre-signed. I was at a meeting about 2 years ago, and the treasurer had a huge stack of checks. She was pre-signing all of them. Timely monthly financial reports should be prepared. A very common element in fraud is the treasurer or the management company get really behind, and you don't see your financials for 3 months, 4 months, 5 months, 6 months. That is a red flag. Other red flags to be thinking about are unexplained cash shortages, overdraft fees, transfers that you don't understand where the money went. Transfers in an electronic transfer should never be allowed on association accounts. Delinquencies. Self-managed associations have a special problem with delinquencies, as do regular associations, but in a self-managed association, lots of times the board doesn't know who to turn to help them get the money. And so what we typically will suggest for a self-managed association is talk to your attorney and say, okay, this person hasn't paid, but don't wait to talk to me until they're 3 years delinquent, right? It's harder for me to collect then. What you want to do is talk to your attorney at 3 months or 6 months and say, okay, we've got this person that's not paying. We've sent them a couple letters. They're still not paying. What should we do? And we can collaborate with you. Typically, we'll run their credit. We'll determine where the money is, if they have money, and we'll give you a game plan and help you with a game plan to get paid. The longer you let a delinquency fester, the less likely you are to collect on it. So really keep that in mind for self-managed associations and regular associations. And then enforcement, make sure you're timely enforcing violations of your documents. You want to make sure that if an owner has a violation on their property, that you are either reaching out to correct it with them, contacting them, because if you wait more than 3 years to enforce a violation, we may have waived our right by inaction. So keep that in mind. Fines and penalties, remember that under the law, associations have the right to fine an owner or penalize an owner for violations of the documents. We have to give notice and an opportunity to be heard before we can levy that fine. And we very frequently see associations setting that up wrong. That means 2 letters. So give them the notice of the violation, give them an opportunity to be heard in that violation, and then after the time for them to be heard expires, then you can levy the fine. Filings, all filings for the association should be current, including the Corporation Commission, IRS, and state tax filings. You have to file taxes, state and federal if you are an association. Reserves, the association should consider having a reserve study completed and a reserve account for your association. What is a reserve study? A reserve study, well, first, what is a reserve account? A reserve account is like a savings account for long-term capital expenditures in your association. And so, you know, what happens is you should have a reserve company, study company come out and, you know, give you an opinion as to your common areas, like how long is the useful life of the pool? And how many more years until we have to replaster the pool? And then they tell you how much money you should be putting away each year to pay for that replaster when the time for the replaster comes. An annual audit, remember that under Arizona law, all associations have to have an audit, review, or compilation every year. We have to have a budget. Remember, we talked about that already. All records must be kept and maintained appropriately. Access to books and records. All records of the association must be made reasonably available to the members of the association with some exceptions. Have a procedures in place for emergencies. Good communication is really important. And then consult with professionals when necessary. Okay, what we're going to do is we're going to take a short break, 5-minute break, grab something to eat, and then we'll come back and finish up with our last 2 subjects. Okay, thank you.